Welcome to the Day of the Dead episode in this year's Halloween-related videos about intellectual property. I'm Julie King of King Patent and Business Law, your witchy guide to all things dark and mysterious in the world of patents, trademarks, copyright, trade secrets, confidential information, and more. I must warn you, this is for educational and entertainment purposes only. This is not legal advice, this doesn't create an attorney-client relationship, and this doesn't make me your lawyer. This final episode in this year's series on Petrifying Patents is a special Day of the Dead episode covering how a patent application or issued patent can die and what happens in the great beyond in the patent world. So how does the ability to file an application die? First, an application can die before it's even begun. Once an invention has been disclosed to the public, a 12-month clock starts ticking, getting louder and louder with each day. If the patent application isn't filed within that 12-month period, it becomes too late to file one for that invention forever. The only hope is to alter the invention enough that it would be considered a non-obvious improvement under patent law standards. This means you need to be very careful about who you talk with about your invention. If you're not ready to start that 12-month window, make sure everyone you speak with about it has signed a non-disclosure agreement. That way, if they blab, and that means you can't file the application in time, you can seek damages from them in court. Of course, that's not going to work for social media posts, appearance at trade shows, etc. That's flat out revealing the invention to the public. While it may be tempting to tease information on social media, don't do it until you're close to being ready to file the application. Same with talking about the invention at trade shows. Hold off on those until you're ready to file within 12 months. So how does an application die? If you've filed a patent application in time, the application itself is in peril during the examination process. The patent examiner at the United States Patent and Trademark Office, or USPTO, searches existing patents, publications, and other public things that may show something identical or very similar already exists. That material they search is called prior art. If they find something identical or very similar, they will reject the application. If the applicant can't come up with a good enough argument about how the invention isn't actually identical or too similar, the application will die. Examiners also look at whether an invention is something capable of being patented in the first place. Many things people think can be patented don't actually fit into the kinds of inventions covered by patent law. Things like abstract ideas or theories can't be patented. Also, patents cover how things work or how things look that are manufactured. There are also plant patents, but those are so rare I'm not going to talk about those. If something doesn't fall into one of those categories, like a logo, it's not patentable, but you may be able to protect it under trademark, copyright, or trade secret laws. If an application is something that isn't patentable, the examiner will kill it. A patent can also be condemned to death if it's for an invention that just isn't very innovative. If it's an obvious change to something that already exists and the applicant can't argue successfully that it isn't, the application will be sent to the chopping block. You can argue against the death sentence, but that's often expensive to do and that's not always successful. Sometimes the examiner is convinced or allows certain modifications and lets the application live. So what happens if an application dies? Usually it means the inventor or other owner of the patent rights is out of luck. Again, you only have a year after disclosing the invention to the public to file a patent application. If the application got published in the USPTO Gazette and added to the public USPTO database before it got killed, that's public disclosure. If you put the invention on sale, that's public disclosure. So if a year has passed between any of that and the final rejection of the application, you are, as they say, SOL. No patent for you. You'd have to change the invention so it's sufficiently different or improved from that application and submit a new application for that. So what about an issued patent? How does an issued patent die? Patents for how things work are good for 20 years and they can't be renewed. However, to keep the patent alive for that whole 20 years, you have to pay maintenance fees 3 times at 3.5 years, 7.5 years, and 10.5 years. If you don't pay those fees, The patent is canceled and is left in the graveyard of abandoned patents. There are short grace periods to recall them from death, but they will cost you a pretty penny. If an invention doesn't make enough money for the inventor or owner of the patent rights, they may decide not to bother to pay the maintenance fees, abandoning the patent to the patent graveyard prematurely. Patents for how manufactured things look, known as design patents, are good for 15 years and they don't have maintenance fees, so they can't be killed off before the end of the patent term unless they're killed off voluntarily by the owner. So what happens when an issued patent dies, whether it's abandoned or merely expires naturally? When a patent dies, the owner of the patent loses those rights. That means anyone can now make, use, offer for sale, or sell or import the invention without the permission of the owner of the patent rights. This is why inventions that make people a lot of money are new and improved regularly. Often those improvements can be the basis for new patents. So the owner might not have rights to the basic invention any longer, but they will have rights for the improvements. And they'll make money because people will buy the new, better version rather than competing copies of the old one. Applying for a patent can be expensive, so it's worth doing the initial work to see if your application or patent may be due for a premature visit from the Grim Reaper or is likely to live to old age. A consultation with a patent attorney can help answer that question, and so can some due diligence on your own part or with the help of a patent attorney in searching existing patents and products to see if your invention is something that doesn't exist already. At the very least, that will help you get an idea of whether you might be infringing on someone else's active patent rights, which is a different and potentially catastrophically expensive kind of horror story. I hope you found this and the other videos this week to be a fun way to learn about patents and patent applications. They're just a drop in the bucket of patent information. So if you want to learn some more, I have information on my website at kingpatentlaw.com. I also recommend checking out all the information at uspto.gov. My contact information is in my bio, so please don't hesitate to reach out and connect or ask questions. Thank you so much for watching.